Ashley Heidemann from JD Advising. Before we dive into our video, let me give you some background on our completely free law school prep course. You can find a link below and sign up to access it right away. And if you find this video helpful, please like and subscribe to our channel. As of this taping, we have literally thousands of students enrolled in this free law school prep course. We're also very grateful that students rated this course an average of 4.76 out of 5. This course is posted as a free resource on the Law School Admission Council, or LSAC's website, and was just mentioned last month by U.S. News & World Report and the National Jurist as being a helpful law school resource. It has also been promoted by the National Black Law Students Association, Phi Alpha Delta, and various law schools and undergraduate institutions across the country.
In this video, we're going to cover legal vocabulary terms that every law student must know. We recommend that you follow along with the illustrated guide. We are going to go through the basic steps of what happens in a civil and criminal lawsuit so that you're aware of these steps and the vocabulary terms that go along with them. We are going to start with a civil case. In a civil case, the defendant does something that the plaintiff does not like. In the first drawing, the defendant breached a contract with the plaintiff, and the plaintiff is unhappy. The plaintiff is the one suing. You can think of it as the plaintiff is the one complaining, and the defendant is the one defending themselves in a lawsuit. The plaintiff will have to decide where to file a lawsuit, either in state court or federal court. Most lawsuits are brought in state court. Typically, family law issues, contract cases, criminal law issues, torts, and property cases are filed in the state court. Federal court can hear some cases. Federal courts can hear cases based on the Constitution, for example, First Amendment free speech claims, or claims arising under federal law generally. Or in some cases, if the parties are from different states and they're fighting over a large amount of money, over $75,000, then their case can be heard in federal court. You will get more into the nuances of these rules and the requirements in your civil procedure class, but you have the basics that you should know in the handout. The plaintiff will begin a lawsuit by filing a complaint in the appropriate court. After filing the complaint, the plaintiff will have a certain amount of time to serve the complaint on the defendant. A complaint can have different claims in it. For example, if an employee sues her employer for breach of contract, that may be one claim. But the employee may also have a fraud claim against the employer. That would be another claim that would be found in the complaint. The complaint tells both the court and the defendant what the plaintiff's claims are against the defendant and what the plaintiff wants. After filing the complaint with the court, the plaintiff has to let the defendant know that they are being sued. This happens by serving the defendant. There are different ways this can occur, but a common way is service by process server, someone who will hand the complaint to the defendant. This gives the defendant notice. The defendant will then answer the complaint. The defendant can admit, deny, or say he doesn't know how to respond to the paragraphs in the plaintiff's complaint. But basically, the defendant is required to provide some kind of response to the plaintiff's complaint. Next, discovery begins. This is when information is being shared or discovered between the parties. The United States has a very open-door policy for discovery, and a lot of information can be discovered prior to trial. During this time, interrogatories, which are questions, can be sent to each party. Additionally, requests to admit facts and requests to produce documents or items can be sent between the parties. For example, plaintiff can ask the defendant to produce the contract that both of the parties signed. Also, sometimes depositions are taken during discovery. A deposition is when a party to a lawsuit asks questions to another party or witness under oath. Sometimes during this process, a motion will be filed in court. A motion is a way for a party to ask the court to do something about an issue. For instance, maybe the defendant wants to dismiss one of the claims that plaintiff is bringing. They can file a motion to try and prove why this should happen. If the case does not settle, which most cases do, It will go to trial. The trial can be in front of a jury. This is called a jury trial, or in front of a judge, which is called a bench trial. During trial, both sides can call witnesses to testify. Testify just means to speak under oath in court. The burden of proof is on the plaintiff to prove her case by a preponderance of the evidence, in most cases. You can think of this as being over 50%. So long as the plaintiff can show that it's at least more likely that her version of the story is true, the plaintiff will prevail. If the plaintiff cannot show that they will prevail, they will lose. A jury will reach a verdict, or a judge will reach a decision and issue a judgment. The verdict is basically the jury saying who wins, and the judgment is how much money the prevailing side is entitled to recover, or what the prevailing side is entitled to in terms of relief, if anything at all. For criminal and civil cases, sometimes the court will write an opinion, which basically says why the case turned out the way it did. And that's what we call the rationale. Courts usually cite precedent, which is binding law. Remember that lower courts have to follow the law as interpreted by higher courts. So, for example, if the Supreme Court of the United States says something, they're the highest court in the United States. So all the other lower courts have to follow what they say. Rules of law come from the Constitution. For example, the U.S. Constitution or a state constitution. Or rules of law come from case law or common law. This is created by judges when there is no controlling law. So most of what you read in law school will be case law. And lastly, rules of law come from statutes. These are express statements of law written by the legislature. A party that is unhappy with the decision can appeal it. There is an appellate system at both the state and federal court level. Every state has their own system and their own terminology, but I'm going to tell you generally how the appellate system works. First, the case will be heard by the lowest court. This is the trial court or the district court. Generally, just one judge hears the case and they render a decision. The party who loses or any party who is unhappy with that decision can appeal it. The next court is the Court of Appeals or the appellate court. Generally, 3 judges will listen to what that party has to say. And if a party is unhappy with what the appellate court decides, then they can appeal up to the Supreme Court. This is the highest court of the land. There are 9 justices on the United States Supreme Court. The reviewing court is usually bound by the facts that the lower court found, but can decide areas of law. This means the reviewing court is not going to rehear all of the evidence. Whatever the lower court found in terms of the facts, the reviewing court will accept as true. The reviewing court will look at how the law was applied to the facts, and they'll do 1 or 2 of 3 things. They can affirm the lower court's decision. This is the court basically saying, yep, you are right. We agree with you. Thus, affirm is just a fancy way to say, we agree with you. They could reverse the lower court's decision by coming to the opposite conclusion as the lower court. Or they can remand the case back to the lower court and tell the court to find more facts. Thus, remand is just a fancy way of saying sending it back. Sometimes the court will write an opinion to say why it decided the way it did. Sometimes the opinion will include a concurrence or a dissent along with the majority opinion. The majority opinion is the opinion that is agreed to by the majority of the judges. For example, that would be if 6 of the 9 judges agreed. The concurrence agrees with the outcome, thus they concur with the outcome, but they do not necessarily follow the rationale of the majority. Essentially, the concurrence is saying, yes, the case should turn out this way, but for a different reason. And lastly, the dissent disagrees with both of the outcome and the rationale. The dissent is essentially saying, nope, this case should not turn out this way at all, and this is why. So that's a general overview of the civil justice system. Next, let's talk about an overview of the criminal justice system. In the criminal justice system, there is also a defendant. The defendant does something illegal and he is arrested by the police. In the criminal justice system, there is not a plaintiff, but instead a prosecutor. The prosecutor brings a charge, sometimes called an indictment, against the defendant. The charge can be for a felony or a misdemeanor. A felony is more serious than a misdemeanor. The prosecutor has to prove the elements of a crime beyond a reasonable doubt. This is a higher standard than the standard used in civil cases, because more than just money is at stake. Here, it is the defendant's liberty and maybe even life that's at stake. Therefore, the prosecutor has to prove beyond a reasonable doubt that the defendant committed the crime. Virtually every crime includes two elements: a guilty act, also called an actus reus, and a guilty mind, also called a mens rea. This means the defendant has to do something and must also have the requisite mental state while doing the act. For example, if the defendant walked up to somebody and intentionally shot them, this is the defendant doing the act with the guilty mental state. It was intentional. This is different than someone who is driving down the street and a pedestrian comes out of nowhere and gets hit. In the latter example, the driver was not intending to hit the pedestrian. Thus, there was not a guilty mental state at the time the action occurred. Thus, in order to be guilty of the crime, you need the guilty act and the guilty mind. In most cases, instead of going to trial, the defendant will agree to a plea bargain, where the defendant and the prosecutor come to an agreement. This is the typical way that most criminal cases resolve. Alternatively, the case will go to trial, where the defendant will either be convicted, so found guilty, or acquitted, basically found innocent of the crime. All right. So that wraps up our general overview of the criminal justice system. Hopefully this vocabulary will help you as you move through this course and start your first year courses.